you need to know about a massive legal victory that just happened. A federal court has just struck down the government's main excuse for denying bond hearings to millions of detained immigrants. The ruling is a Matter of Yajure Hurtado. The decision the government was hiding behind has been vacated. But here's the big problem. The government is refusing to comply. ICE is still holding people without bond hearings, in direct defiance of a federal court order. And that means one legal tool is more important than ever. It is called habeas corpus, and federal judges across the country are using it to order ICE to release people, and sometimes within days. Today, I'm going to break down exactly what just changed, what it means for your family, and how habeas corpus is forcing the government to follow the law. Stick with me, because by the end of this video, you will understand how the Bautista ruling changed the landscape, exactly how habeas corpus works in immigration detention, when you should use it, what the process actually looks like, step by step, and how to find the right immigration lawyer to help. Hi, I'm immigration attorney Julia Sverdloff, and I have been practicing and guiding people through this process for over 18 years. I have seen this tool change outcomes for families who thought they had no options left, and the information I'm about to share could make all the difference for someone you care about. What just changed? Hurtado vacated and Bautista ruling. To understand why this moment matters, you need to know what happened and what just changed. In 2025, the Board of Immigration Appeals issued a decision called Matter of Yajure Hurtado. And that ruling said that immigration judges no longer have the authority to hold bond hearings for anyone present in the United States without lawful entry. If you were not inspected and admitted at a port of entry, the government considers you subject to mandatory detention. No bond, no hearing, indefinite. On top of that, the Laken-Riley Act, signed in January 2025, expanded mandatory detention immigration rules to include anyone simply arrested for certain offenses, not convicted, arrested. The result was a detention population that surged past 73,000 people, the highest number in ICE's entire history. Roughly 3 out of 4 of these detained, have no criminal conviction at all. But here's the critical update. In the case of Bautista v. Sanchez, a federal court judge in California's Central District issued a final judgment, declaring that this policy of indefinite detention without bond hearing is unlawful. The court certified a nationwide class of people affected and ordered relief. And then, on February 18, 2026, when the government still refused to comply, that same court vacated Matter of Yajure Hurtado entirely under the Administrative Procedure Act, or the APA. That means the legal basis for the government was using to deny bond hearings has been struck down by a federal court. The court also ordered DHS, ICE, and EOIR to notify every potential affected detainee of their rights, including the right to request a bond hearing. Detention facilities are required to post notices. ICE officers must hand them to new detainees. Immigration judges are ordered to confirm people receive them. This is a landmark development. But, and this is the important part, the government has a track record of defying this court order. Over 550 habeas petitions were filed in just one federal district court in the weeks after the original final judgment. Federal judges across the country have granted over 400 habeas petitions from people in this exact situation since December 2025. The government keeps resisting, and that is why habeas corpus remains your most powerful tool right now. There's one more wrinkle you need to know. The Fifth Circuit, which covers Texas, Louisiana, and Mississippi, issued a contrary ruling in a case called Buentrostro Mendez v. Bondi. The court sided with the government. So where you are detained in the country now matters more than ever. And that is exactly where habeas corpus comes in. What is habeas corpus and why is it working? Habeas corpus is Latin for produced body. It is one of the oldest legal protections in existence. It is written directly into the United States Constitution. It is one of the oldest legal protections in existence, and it is written directly into the United States Constitution. When you file a writ of habeas corpus, you're asking the federal judge to review whether the government has the legal right to keep someone locked up. And that is not about whether someone wins their immigration case. This is not about guilt or innocence. A habeas corpus petition asks one simple question: is the detention lawful? And right now, federal judges are answering that question loudly and clearly. Over 400 rulings from federal judges across the country, including judges appointed by presidents of both parties, have rejected the government's position on mandatory detention since Bautista final judgment alone. They're finding that the way ICE is holding people is not supported by the law. In many jurisdictions, attorneys report success rates over 90% on habeas corpus. Courts have ordered bond hearings that ICE refused to provide. They have ordered outright release when detention stretches on for months without justification. And they have demanded medical care for detainees with health emergencies. The Bautista ruling has made habeas even more powerful. You now have a federal court judgment, a vacated VA decision, and an ordered class notice, all backing up your right to a bond hearing. But here is something critical you need to understand before you file. Not every case qualifies, and the process has specific rules that vary depending on where your loved one is being held. How does filing a habeas corpus actually work? Let me walk you through the actual process, because knowing these steps could save you weeks of confusion. Step 1. Find out exactly where your loved one is being held. This sounds simple, but ICE transfers people between facilities constantly, sometimes across the country, with little or no notice. You may need to use the ICE detainee locator or work with an immigration lawyer to track them down. The location matters because a habeas petition must be filed in a federal district court where the person is physically detained. And different circuits are reaching different conclusions right now. Step 2. Gather the facts. When were they detained? How long have they been held? Was a bond hearing requested and denied? Did the immigration judge or ICE cite mandatory detention or Yajure Hurtado? Were they given Bautista class notice? Has there been any progress on their case at all? Every detail matters. Step 3. The petition itself gets drafted and filed in federal court. This is a written argument to a federal judge explaining why the detention violates the Constitution or federal court. It names the facility warden or director as the respondent and lays out the legal basis for release. Now, with Hurtado vacated, your attorney can point directly to the Bautista ruling and the APA vacature as a powerful authority. Step 4. The petition is served on ICE and the U.S. Attorney's Office. The judge will then decide whether to hold a hearing or rule based on written filings alone. Step 5. If the judge rules the detention is unlawful, they can order the release. Sometimes the release comes with conditions like GPS monitoring or bond amount. In some cases, judges have ordered immediate release. Now, I want to be honest with you. This process takes time. Federal courts have their own pace. But when the immigration system has gone silent on your case, when there is no bond hearing and no court date and no answers despite the federal courts saying you are entitled to one, habeas corpus is often the only way to force the government to act. What are the risks and challenges? I would not be doing my job if I only told you the success stories. There are real challenges you need to know about before you go down this road. First, it does not always work. Federal judges do not grant every petition. You have to show a clear legal violation, whether that is prolonged detention without a hearing, a misapplication of the mandatory detention statute, or a constitutional rights violation. Second, the law varies by circuit, and this matters now more than ever. The Bautista court in the Ninth Circuit, the Fifth Circuit covering Texas and Louisiana, has reached the opposite conclusions. What works in one part of the country may play very differently in another. That is why working with an immigration lawyer who knows your specific federal court is essential. Third, filing habeas corpus does not stop your immigration case. Even if you win the release, you still have to fight deportation through the immigration court system. Release is not the finish line. It is the chance to fight your case from home instead from behind bars. Fourth, some families worry about retaliation. Will ICE punish someone from filing? In practice, federal courts take a very dim view of retaliation, and the right to file a habeas corpus is constitutionally protected, but it is a concern worth discussing with your immigration attorney upfront. And here's one more thing that catches people off guard. Sometimes habeas corpus is not even the best first move. If the Bautista class action notice has been served and a bond hearing is being scheduled, it may be smarter to pursue that hearing first. A good immigration lawyer will evaluate the full picture before recommending a filing. How to find help right now? If someone you know is detained by ICE and you feel like every door is closed, here's what I want you to do. Start by contacting a qualified immigration lawyer, specifically one with experience in both immigration court and federal court habeas filings. These are two different systems and you need someone who's comfortable with both. Ask whether your loved one falls within the Bautista class. If they were detained without a formal admission and deny a bond hearing, they very likely do. That class action notice entitles them to request a bond hearing, and if the government refuses, habeas is the right step. Gather every piece of paperwork you have: ICE notices, detention records, bond decisions, the Bautista class notices, if they received one, letters from employers or community members, anything that documents the case and shows ties to the community. Act quickly, but do not act blindly. The sooner you get legal advice, the more options you have. But rushing into a filing without understanding the full picture can cost you your future and credibility with the court. And stay connected. Detention is designed to isolate people. Stay in contact with your attorney and with your family member. It could make all the difference in the outcome. Let me bring it all together. Here is what you need to remember. A federal court has vacated Matter of Yajure Hurtado, the decision the government relied on to deny bond hearings to millions of people. That is a massive win. A nationwide class has been certified, and the court has ordered the government to notify every affected detainee of their right to a bond hearing under the law. But the government is fighting this ruling and has a documented history of noncompliance. That is why a habeas corpus remains the most powerful and proven tool for getting someone out of ICE detention. Federal judges across the country are granting habeas petitions at an overwhelming rate. The process takes work and it takes patience, but when the system is stacked against you, habeas corpus is how you force the government to follow the law. You're not powerless. Families have rights, and there are legal tools available to challenge unfair and unlawful detention, even against the agencies as large as ICE. If you or someone you love is in immigration detention and you feel trapped, do not lose hope. Help is available, and you do not have to face this alone. We just broke down how a federal court struck down the government's excuse for denying bond hearings and why habeas corpus can be a lifeline for release from immigration detention. It is not just paperwork, it is a fight for freedom, families, and basic rights. But do not stop here. If you're a green card holder or you have one in your family, you need to watch the next video. Green card holders, is it safe to travel under the Trump administration? We're seeing a lot of confusion and even heartbreak at the airport right now. And you deserve to know the facts before you buy that ticket. Click over to the video now. It could protect your status and keep your family together. See you over there.